invite Senator Deacon, Nova Scotia.
Thank you, Your Honour. Honourable colleagues, I'm rising to speak to Bill C-47, the Budget Implementation Act 2023. You might expect me to focus on the billions intended to spur business investment, but I think Senators Lafreda and Marshall have done a great job there, and I'll move on to something else that I'm a little bit more focused on. And that's Division 39 of Part 4, at the very end of this 430-page bill. It seems innocuous enough, introducing what seems to be a reasonable amendment to the Canada Elections Act, the stated purpose being to, and I quote, provide for a national, uniform, exclusive and complete regime applicable to registered parties and eligible parties respecting their collection, use, disclosure, retention, and disposal of personal information, end quote. When I read this, however, a couple of thoughts came to mind. Number one, using a budget bill to change the Elections Act challenges the long-standing practice of openly debating these changes in Parliament and arguably sets a troubling precedent. And two, given that there is actually no, and I quote, national, uniform and complete privacy regime, end quote, governing how the federal parties currently, quote, collect, use, disclose, retain, and dispose of personal information, what's going on? You may recall that we passed the Elections Modernization Act in December 2018. It allowed for political parties to self-regulate their collection and use of personal information linked to Canadian voters, as long as they published their privacy policies. And this is what the Privacy Commissioner was referring to when he spoke to our legal committee, that was a good first step, that they published those privacy policies, but those privacy policies don't live up to the 10 principles under PIPEDA. And he also stated that he has no jurisdiction in which to investigate or comment on those privacy policies. So these voluntary policies are actually not uniform, and they're not complete, and especially when you compare them to any reasonable international norms. These voluntary policies don't reflect on the privacy protections that corporations or governments must follow, and particularly as it relates to the areas of consent, transparency, and accountability. Looking back, I was a bit naive to think any group should be entirely free to regulate their privacy policies. But that's where we are. No uniform and complete privacy policies govern federal political parties at this time. In their study of C-47, our Legal and Constitutional Affairs Committee noted that privacy safeguards, or the lack thereof, can impact Canadians' trust in political parties and, by extension, the electoral process. They recommend that amendments to the Elections Act should follow consultations with the Chief Electoral Officer and the Privacy Commissioner, and be introduced through a separate bill to allow for thorough study, noting neither occurred in this case. Well before the Facebook Cambridge Analytica scandal, which was the non-consensual use of private information of tens of millions, and it was used maliciously to influence voters in various elections, before that, the Privacy Commissioner and Chief Electoral Officer were speaking about voter privacy. For example, in 2012, they raised serious concerns about the lack of privacy protections for Canadian voters. 2 years later, in 2014, then Minister of State for Democratic Reform, Pierre Poilievre, introduced Bill C-23 called the Fair Elections Act. It offered no privacy protection to Canadian voters. Another 4 years passed. In 2018, Karina Gould, then Minister of Democratic Institutions, testified in defense of Bill C-76, the Elections Modernization Act, before our legal committee. When asked about self-regulated privacy protection, she pointed to the need for, and I quote, a study to be conducted for parliamentarians to examine how political parties could be part of a system to protect personal information. Interestingly, just as Bill C-76 received royal assent, the House of Commons Standing Committee on Access to Information, Privacy and Ethics published just such a study called, and I quote, Democracy Under Threat, Risks and Solutions in the Era of Disinformation and Data Monopoly, end quote. The House Ethics Committee study was in direct response to the Facebook Cambridge Analytica scandal. This group of elected MPs from across the political spectrum recommended urgent action, including subject political parties to the Personal Information Protection and Electronic Documents Act, or PIPEDA, including their contractors like social media platforms, data brokers, polling firms, and consultants. Grant the Office of the Privacy Commissioner and/or Elections Canada the mandate and authority to conduct proactive audits on political parties regarding their privacy practices and issue the ability to issue orders and levy fines. And enact legislation requiring social media companies to create publicly searchable databases of all political advertising, label political advertising, label content that is produced automatically or algorithmically, remove accounts that impersonate others for malicious reasons, and remove harassing, threatening, or maliciously manipulated content like deep fake videos, among other recommendations. To date, Canada's federal political party leadership has ignored these recommendations from their own caucus colleagues on the House Ethics Committee. Soon thereafter, the Privacy Commissioner and the Chief Electoral Officer issued a joint statement requesting that our federal political parties voluntarily adopt privacy policies that align with international privacy law standards and that are based on the principles of consent, transparency, and accountability. Little or nothing has changed. I encourage you all to read the various privacy policies of our federal political parties to find evidence that any party has voluntarily implemented the recommendations I've just cited. I did not. So why is Division 39 even in the budget bill? It seems to be that in 2022, the British Columbia Privacy Commissioner ruled that the federal political parties must adhere to BC's privacy regime governing political parties, and I suspect that's in response to persistent inaction. The Commissioner listed the array of personal data collected without voter consent. It's eye-opening. Political party privacy policies give voters the right to correct inaccurate information, but those voters have no right to access the information. It includes information from the voter registry, but also information scraped from the internet, gathered through apps and social media, and by door-to-door canvassers. You currently have no right to ask political parties to stop sharing your information with a third party like a consultant, polling firm, or social media platform. And if they suffer a cyber breach, like the government database breach that just affected 100,000 Nova Scotians this past week, they have no obligation to let anybody know. Corporations and governments are obligated, and for good reason. These federal political parties have ignored more than a decade of recommendations from the two officers of Parliament responsible for these issues. They've ignored the House Ethics Committee's carefully researched recommendations. And when BC decided enough was enough, the Liberal, Conservative, and NDP parties challenged that decision in BC's Supreme Court. In these hyper-partisan times, I have to say it's truly remarkable that this is the one issue that Conservatives, NDP, and Liberals all agree on. So why are they fighting so hard? One reason is that each party has an enormous database of granular data linked directly to identified voters. Conservatives have their Constituency Information Management System, or CIMS, the Liberals have Liberal List, and the NDP have NDP Vote. Each party also has apps that gather extensive data and advanced information management systems to process all those data. Canadian voter data has many uses, including enabling micro-targeting of political messaging to like-minded voters within the broader population. When these political party databases are combined with the staggering amounts of highly personal data held by Facebook and other social media and big tech companies, their sophisticated methods can accurately predict who will respond to which type of political messaging with almost instant results. I liken micro-targeting to digital gerrymandering. It turbocharges highly divisive wedge politics. Political organizers openly admit that voters no longer choose their political parties. Political parties choose their voters, and I, for one, find this a bit troubling. I first learned about micro-targeting 11 years ago in listening to an Under the Influence CBC Radio 1 show hosted by Terry O'Reilly. I encourage you to listen to his 30-minute archive podcast from April 28, 2012. You'll start to understand why the House Ethics Committee titled their report, Democracy Under Threat, Risks and Solutions in the Era of Disinformation and Data Monopoly. They saw the current political party privacy that was posing a risk to our democratic and electoral reform process, and they recommended urgent action to protect Canadians and democracy. So what do Canadian voters think about political party privacy? In their report on the 2021 election, Elections Canada found that 96% of Canadian voters want laws to regulate how political parties collect and use their personal information. Our current federal laws are completely at odds with Canadian voters on this issue of trust. Regardless, the three political parties continue to defiantly ignore the repeated recommendations that they begin to adhere to international privacy standards and third-party oversight, that they begin to obtain consent prior to collecting personal information, and inform citizens of a personal information breach that might cause them significant harm. These risks are not hypothetical. In January of this year, the Green Party voluntarily announced the accidental release of names, addresses, phone numbers, birth dates, and other data related to its party members and supporters. Importantly, they were under no obligation to do so. Would other parties do the same? We may never know. Does the highly personal data held by the other three national political parties benefit from some exceptional cybersecurity protections? I certainly hope so. That's because foreign adversaries could use these troves of detailed personal information to sow division right across Canada. There's been a lot of talk about foreign interference in our democracy this year. Yet these parties continue to ignore the risks highlighted by their own MPs 5 years ago. Just imagine how unprecedented volumes of granular data tied to identified Canadian voters could enhance the clandestine efforts of Canada's adversaries, especially as we enter the era of generative AI built on large databases. This makes our political parties highly valuable cyber attack targets. And if it happens, they're under no obligation to tell us. Canadians are increasingly at the wrong end of a data vacuum. It's now estimated that each Canadian generates an average about 2 megabytes of data every second. For perspective, the complete works of Shakespeare are about 5 megabytes of data. So that's about 2.5 seconds worth of the data that each of us generate from our digital devices and activities. That's why citizens want control of their data, and in most countries they have it. We know that there's a lot of it, and we don't know what is done with it. Our Senate Banking Committee has been examining the issue of business investment in the digital era. We've heard from venture capital investors and founders from some of the most incredibly fast-growing tech companies. Each one relies on data to create value that they export globally. They all emphasize that their company's success demands that they establish and maintain a strong social contract with citizens, this being the right for individuals to control their data and have confidence and trust in how those data are used. In the opinion of these globally successful investors and entrepreneurs, this social contract, this trust, is foundational to Canada's future prosperity. In a recent op-ed in the Hill Times, University of Victoria political scientist Professor Colin Bennett, who's been researching this issue for more than a decade, wrote that, and I quote, "Political parties are regulated under privacy law in almost every other democratic country in the world, including those regulated under the European Union's General Data Protection Regulation, or GDPR. The regulatory gap in Canada has become untenable and indefensible." So where to from here? Well, we know what hasn't worked. The leadership, executives, and boards of the NDP, Liberal, and Conservative parties have consistently ignored the will and advice of the two officers of Parliament responsible for privacy in elections. They've ignored the House Ethics Committee, and they've refused to voluntarily adopt privacy policies that align with global norms. Instead of heeding this advice, the government now is including, in the BIA of all places, a Band-Aid clause that allows for the three parties to maintain the status quo. Perhaps we should invite the presidents of these federal parties to explain the reasons and evidence behind their inaction. Maybe they have evidence that somehow democracy in Europe has been undermined by GDPR's voter privacy protections. Like corporations and governments, political parties need to start adhering to strong international norms and give individual Canadians control over their personal data and its use. Not only is the resulting trust central to individual and collective sovereignty of Canadians, it's foundational to our future prosperity and democracy. Thank you, colleagues.